every single friend I'm in our call BM for once any says I want subscribing but more than subscribers and be a big updated. Now yes every in feeling chim na the Chief Justice. I am also the outcome. A Chief Justice Mammy Torkonoo case no updated by him somebody be na say ye in no and ECOWAS court a jack case meanwhile Mammy Torkonoo the coroner. Amabo baako atogu and ọmọ accept baako na de aka no de esi ya mother attorney general 30 days or ultimatum say ofambra ECOWAS court na niema ebobo bana abc no I think say afeyuma kin kasa ne ade ade ni nyina no ade a ebekọ fom na woni bibi sabre Maame Torkonoo da outgoing chief justice ne lawyer ayiko otu ababontin edin sembe bre ababeto abontin a yebekwa akwoti ne kasa no na utim se ahyem ye pa no chese bebi a case na dru no kra de ruling bi ababia hakampa enhyedan necessary sa enkudin kotin senum chichimu
ba yebeto aso na afei ye di enkomo ntina meka former CJ na semodi ko ECOWAS court no from the report from the court, no meaning say court ne say omo jurisdiction to hear the substantive matter in the omashe AG say in 30 days time no was say AG file on also a response. Meanwhile, the applicant in this case Chief Justice, former Chief Justice SIF file an application for some provisional measures, which provisional measures was to stay the hands of the committee and investigations. No say, hold it on. And on a court, Nika said the threshold of urgency, was not met. In the omo dismisses application, but on the substantive issue, the court say yes, more jurisdiction to hear, and the Chief Justice prima facie etimi raise issues are here as a court no omutimi ehwem, and that's the detailed report at the law platform at the etuja enti enye it was the two interlocutory rulings and a court na and one was to dismiss sa application for provisional measures and a one and so on the court's jurisdiction to hear the matter no court na ruling say yes for more jurisdiction to hear the matter. And we're calling on the Attorney General to file a response in 30 days. That's for the substantive application. That's what the law platform at the Atuja. Mamenkwa Omanis when him say the former CJ, the lawyer ni Ayikwe Otu Esquire, former Attorney General of the Republic of Ghana, and was served as Ghana a High Commissioner to Canada. And so Eda ma yeneno ini enkomo. Council, good afternoon.
Hello.
Good afternoon and welcome. I hope you are doing well.
I am.
Good. Are you back from Nigeria? Hello?
I'm back on Akroma. Many years when my friend passed away.
Yes.
Nobody calls me in the afternoon anymore.
So give us an idea. What was the ruling from the ECOWAS court today?
Well, I have been saying that. In fact, I don't think what has happened is even newsworthy. Newsworthy in the sense that when the government as well as the committee started doing things which will prejudice FM. Some of us sounded the alarm bells. You see, if you remember, they had not finished hearing all the petitions. Out of the 3 petitions which His Excellency the President asked them to inquire into, they inquired into only one. And in an indecent they rushed and went and presented a report to the President. The same day, the President said he had accepted the recommendation that the CJ be removed. When indeed they had not finished doing the other petitions or inquiry into them at all. So if you are given 3 petitions and you finish 1, where is the evidence that you have complied with the orders given to you or directives issued to you? Now, we did say that there were cases pending at the High Court and the Supreme Court, and that it would be better for all these things to be cleared out of the way before government embarks on making a nomination to the position of Chief Justice. The government didn't listen to us. It made a nomination. When a person was to appear before Parliament, alarm bells were raised in Parliament. The minority stood their ground to say that what we are doing is not fair. There are cases pending at the High Court, Supreme Court, and ECOWAS Court. So stop it. Just respect the boundaries of authority. The case is pending before the judiciary. You are the executive. Just respect the boundaries. The legislature, which is also an arm of government, can also hold on to respect what the judiciary will say. They will have none of that. And I went ahead, bettered him, and issued their report recommending him. Before anybody could say Jack, they went ahead and swore him in. You see, when you do these things, you are fixing the judiciary with a fiat accompli. That's all they have done. That's what I'm saying. I don't know what they are celebrating. Because for all intents and purposes, as we see today, they have a new Chief Justice. So if they grant an injunction that the removal or the suspension of the former Chief Justice is not proper, would they reverse everything? Would they reverse it?
Yeah, but
so they are saying that for purposes of the interim injunction, let it go. What is newsworthy is the fact that they made a preliminary determination that indeed rights have been violated, and that the Attorney General is given 30 days to respond to the substantive matter, to give them an opportunity to hear the case. That is not an interim matter. That will be the substantive matter. So once the substantive matter, a judgment is given which says that whatever they did was wrong, it will be left to the President. And here is Attorney General going about saying that whatever the courts will say, they will abide by it. I hope you have heard that one.
Yeah, I have.
So we are not worried about any interim. In fact, to make the point that in October, lawyers wrote to the ECOWAS court to say that the things have taken so long and that we are no longer interested in the interim measures.
Okay.
And that they should rather give us a date
for the substantive issue.
Those letters are also being circulated.
So for you as counsel, you were expecting the kind of ruling from the court on the application for interim measures that the court may come to the conclusion they came to today, right?
Saying that we had even written the Nigerian solicitor, Falana, to the court already.
Okay.
That they should not waste their time on that matter, but should rather proceed to consider the matter itself.
Okay. And you had also applied for a default judgment. Is that the case?
Because they have refused to file their response from the time the matter went there.
Sure.
You remember recently in Parliament, Afenyo Markin made that point that they waited when the Chief Justice nominee was to appear, then the Attorney General went to court to say that he wanted extension of time. And he was given 3 weeks to go and file it. So although they have been going about telling everybody that indeed there are cases pending before the Supreme Court, they had in fact not responded to any of them. They had not responded.
But
so this is nothing. I mean, I don't know what it is that we are talking about. Let me read this one to you. We have a little time. Reinstitute Tomasuso and so Torkonoo of the Republic of Ghana notification on breach of lease pending and request for date to hear substantive suits. The above subject matters referred is we are counsel representing the plaintiff in the above reference suits. The plaintiff commenced a suit seeking the enforcement of fundamental rights in relation to a position as a substantive Chief Justice of Ghana on June 30th, 2025. Although the defendant was served with both a substantive suit and motion for interim measures, the defendant state elected to respond to the interim measures that were held on July 14, 2025. Despite the pendency of the suit challenging the plaintiff's suspension and seeking an order to restrain the defendant's state, the President of the Republic removed her as a Chief Justice of the Court on September 1st. That time, the motion had already been heard. He went ahead and removed her. Thus, this Honorable Court has been presented with a fiat in an apparent move to present this Honorable Court with a fiat complaint and thereby undermine the independence of the judiciary. Even though the defendant has disregarded the hallowed principle of late pending, the ruling of this Honorable Court on the provisional measures, by mark my words, will no longer be necessary. Let me repeat it. The ruling will no longer be necessary as it has been overtaken by the contemptuous act of the defendant. We are, on account of the foregoing, compelled to request for the shortest possible date to hear the substantive suit. So what are they celebrating?
Oh, okay.
What are they celebrating?
And I think what also generated this controversy was in an attempt to update the rest of the country on what happened at the ECOWAS court, the Deputy Attorney General concentrated on the court's ruling relative to this, interim application, i.e. the one seeking provisional measures. And in his update, he made the point that the court has thrown out that application. In that update as well, he didn't touch on, the fact that the court has ordered the Attorney General to file their response in 30 days relative to the substantive matter. And that's what I think has created this whole, controversy on social media especially.
Well, they are playing politics. It's always in politics. So they are just playing politics, just as they told everybody that they cannot work with her. They cannot reset the judiciary with her. And then when they come, they will remove her. So the whole thing was just trumped up. Got some people to write some petitions, quickly got others, the Council of State, to say we have found a prima facie case. And then they went ahead, everybody set up a committee. Yeah. And you saw the reasons that were given, and they don't make any sense. How can a head of judiciary be said to have engaged herself in misconduct for transferring a worker? Not that he even dismissed the worker, but for transferring the worker. They say that amounts to, better misbehavior. And when the person in charge of the accounts, the spending officer, had explained that she was entitled to travel with other persons, they still said that for them, they owe the liable for whatever it is that has happened. I mean, you look at the grounds, they are no grounds. They are nothing. You said you have made a prima facie determination. He said, show me the prima facie determination to enable me to prepare so I can come and appear before your former committee which you have set up. You said you will not have none. You will not give it. So she was never given the grounds for the so-called prima facie determination. Up to today, we have not seen it.
So you are saying when she wrote to the president that she would want to be heard before the prima facie determination, the president granted her that opportunity,
yes,
asked her to respond, which she did, and yes, then the Council of State together with the president came to the conclusion that there are some prima facie determinations that have been made. You are saying those determinations and the basis of those determinations were not made available to her?
Never, up to today. And meanwhile, you know the meaning of prima facie.
Sure.
You just on sight, at first sight, at first blush. You haven't gone into the merits, but you just say that, wait, I've seen some prima facie matters. So you go and see whether you confirm what it is that are taking place or what we have seen to be wrongdoing. For example, you remember somebody said she traveled and she was giving a per diem, and that she didn't retire the per diem. It was a blatant lie. She retired everything when she arrived back here. So assuming you have used this as a prima facie determination that she has refused to retire some money's, accountable interest. Now you found that what they are saying is wrong. You understand? But you never even showed them what the so-called prima facie determination was. But yet you ask her to go and appear before a committee and answer whatever charges have been laid against her. Now, if you remember, there were over 23 or 20-something charges. They said they found only 3 proving. And the 3 themselves were so hollow, useless grounds, that they said they have found that.
So when you went before the committee may have read the details of the prima facie determination to your client for her response, no?
Why are you saying may have? If they did that, why should we complain? You said they may have, which is the same as might have. So you are only the man's thing. It's not true. They didn't.
They didn't do that?
Asking them several times. I made several. Those of you who have seen the reports, if they recorded them, if they did faithful recording, you will see it. We asked more than once, about 3 times, that we have not seen the prima facie determination, and we don't know what it is that we are answering. They won't mind it. They even at one stage they told us that it is not for them to supply it to us. It was the president and the council of state, so we should go there.
And did you make that attempt to go there?
We didn't worry ourselves. Because if he says he has given it to them to confirm or deny whether those things are true, then they had it in their custody.
Yeah.
That is what they are going back. So they are the proper persons to give it to us.
As far as your client is concerned, I mean, based on all the pending applications before the court, which applications, if determined in her favor, would mean that her removal was unconstitutional? I get a sense that your client does not recognize the fact that there is, for the want of a better expression, a new Chief Justice in place, right?
Well, we're not in court before the new Chief Justice was sworn in. So what question are you asking?
No. I'm asking...
Are you saying we have now gone to court after he has been sworn in?
No, that's not what I'm saying. I'm saying because of the pendency of all the applications in court, you disagree with the fact that the executive should go ahead and nominate, vet, and swear in a new Chief Justice.
We said all that and they didn't listen to us. So what are you saying now? They didn't listen to us. We told them to hold on. You all saw what happened in Parliament. Even today, from what we are hearing, some majority people are saying Akroma has brought the parliament to disrepute and that it should even be punished for what he did. Now, what was it that he was saying? All he said was that there are cases pending. Can we please hold on? It was not the long and short. Was that not the long and short of all that Akroma was saying?
Yes.
So we said everything. They didn't listen to us.
I believe you are still waiting anxiously for the court in Ghana to fix date for the various applications before the court here in Ghana, right?
You heard Akroma saying that in the Supreme Court case, just like the ECOWAS, they refuse to file anything. All that they are interested in is in filing to contest interim orders. Because that one too, there was an interim application which went to the Supreme Court, the lead judgment being rendered by Madu Tanko, if you remember.
Yes.
So that one, they quickly filed their papers. In the same way, when we asked for special right, they quickly went there. When we were not given a date, then they filed saying that the court had no jurisdiction.
I was out for a ECOWAS just say on a get treat a Torkonoo a former Chief Justice on a Sabre as you speaking or a lawyer. Just say ECOWAS Court, High Court, Supreme Court, on a see or D at Intinimu Emma a get treat a Torkonoo. Just or the same way in our bow. We get any art and some more kind or casa be free. Now, to me, say, why very pain and is said the Cyber speaking a client and ocean a condition warm near my Badria ECOWAS Court no crampono. A board case back on no crampo to go crampo the another say, as some na say, and it's an honor or case no name say, the na a Muhammad dem. Tama 77 no opposition. No name say, Sani man no cano. Na woni se sa na beba no munim se si na beba the thoughts na campaign talks keke na ono de o hwe niam a mugina so pa de gi get Torkonoo edina eni ye ba because was petition na 3 na muye mu baako na no na man for crack say petition na 3 na maye mu baako a tim se baako no mpokura no niam a mo hu wom no itimi gina so ye den edigi na di. Because justification by say na petitions near the A3 and the presidency a committee or no omuye mu baako omure fi say petition no say the petition koma president omuhwem a the tasum no and omuye ho adwuma the ancient tasum no mo de den eto nchen because untimi intro petition based on bias, based on how I was say pain into near the you been through there be I was say wunya a well ground a year requirement just a bit imagine so a day nipa krona pese the in the near because in the packet Ghana nyina Chief Justice o the petition ba also oyem BBC intino muinedi oyem BBC intino muinedi there be onkwa no dey also the aye Ghana fo nyina so on shede ni wow ground eye niema wasi timi gina so edi ne dey ade this petition here den ebeto njan na ayiko to ababantin achire said we say pain said the watch say ade no cramp ne ko wi na se rule man no cramp a was ko hin ye rule mama mi Torkonoo esisi pa ko hin po bafo boni ya nominate no akọ parliament ya vet no about chamber of the parliament ya approve no owie no asa akọ presidency ama president Mahama I den asweni in amasisi no oye na adwuma hwe process wa from nyina wo se de ben de be abent no yembo de ben tungu so po baf bonus still and a Chief Justice as we speak na ono de to ono de hu ne se ahwa na ruling bia akra ba kra chi na ha na ahwa na nkosi hwe because a man for because the attorney general may who say if say court be we are CB about the ruling back a Ghana constitution no more interpreted no more can say the president Mahama Yeninya or Messiah I reverse BBA ama man Torkonoo sayene akako any chief justice na persuade okay but the cases one J court na or preside end ako ECOWAS court or court or presiding the case by unjintum ako ECOWAS court say any ruling ma the same court na unjindin wo person be hu chief justice the ruling ma amount for money amount for jitum now guys okay you sentence you to 20 years nani pakona jatum because the same cost the ruling ba one jantum na so nenam was for 18 same I wait my actual I join the comments subscribe na share mania so the binti Akroma.